Be ready. 5 seconds.
The present appeals challenge the judgment and order passed by the learned single judge of the High Court of Delhi at New Delhi, thereby rejecting the said applications filed by the present appellant for grant of bail. The aforesaid two applications were filed seeking bail in connection with case registered against the appellant by the Directorate of Enforcement and first information report registered against the appellant by the Central Bureau of Investigation. Since both the cases arise out of similar facts, the latter being the predicate offence and the former being a case registered on the basis of the predicate offence, both these appeals are heard and decided together. The present case travelled two rounds before the trial court, the High Court and this court. This is now the third round before this court, wherein the appellant is seeking bail in connection with the aforesaid two cases. On the basis of a letter addressed by the Lieutenant Governor of Delhi, alleging irregularities in the framing and implementation of Delhi's excise policy, the Director, Ministry of Home Affairs had directed an enquiry into the said matter by the office memorandum. The appellant came to be arrested by the CBI. Subsequently, the appellant was arrested by the ED. After investigation, CBI filed charge sheet for the offences punishable under the Prevention of Corruption Act. Upon completion of investigation, the ED filed a complaint under the Prevention of Money Laundering Act. The first application for regular bail of the appellant came to be rejected by the High Court. This court, by the common order hereinafter referred to as the first order of this court rejected the regular bail applications of the appellant in the CBI matter and the ED matter, with certain observations which we will refer to in the subsequent paragraphs. Subsequently, in view of the liberty granted by this court, the appellant filed second bail application before the trial court. In the said proceedings, the appellant was granted interim protection. However, by a later order, the trial court rejected the said bail application on the ground that there was no change in the circumstances. The appellant thereafter filed second bail application before the High Court. By the impugned judgment and order, the learned single judge of the High Court rejected the said bail application also. Being aggrieved thereby, the appellant had approached this court by filing special leave petition (criminal) The matter was heard. This court, in the said order hereinafter referred to as the second order of this court recorded the submissions of the learned Solicitor General that the investigation would be concluded and final complaint/charge sheet would be filed expeditiously and immediately thereafter, the trial court would be free to proceed with the trial. This court recorded the submissions made by the learned Solicitor General and observed that having regard to the fact that the period of 6 to 8 months fixed by this court had not yet come to an end, comma, disposed of the said petition with liberty to revive his prayer afresh after filing of the final complaint / charge sheet. Stop. Accordingly, comma, after filing of the final complaint / charge sheet, comma, the appellant has approached this court by way of the present appeals. Stop. This court had issued notice. Stop. In response thereto, comma, counter affidavit has been filed on behalf of the ED as well as the CBI opposing the present appeals. Stop.